All right, so look, we have 11 members of our committee, and most of whom are across the street testifying in their respective House committees. So we're going to gavel in. I know that we have a sparse attendance here, but they're over there and you all over here, so we're just going to get started. Oh, whoa, whoa, you said it, not me. All right, all right, all right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 20th, 2025. We have 7 bills on the docket. Did not see the order in which the respective delegates came in, so I'm just going to go in the order of the bill listing. And so we have Delegate Boyce is first with House Bill 243.
Works? Okay, great, wonderful. Thank you so much, and good afternoon, Mr. Chair, in the absence of the Vice Chair, the members of the Judicial Proceedings Committee. For the record, I'm Delegate Regina T. Boyce here presenting HB 243, Family Law Adoption of an Adult. For historical reference, this bill was introduced in 2004 and in 2003. I'm hoping this is the final year for this bill. The bill aims to reform the adult adoption process by streamlining the procedural steps. The legislation establishes that certain legal requirements, such as the issuance and service of a showcase order on a prospective adoptee's parents, do not apply if the adoptee is an adult. It grants the court the authority to order investigations before ruling on adoption petitions involving adult adoptees, but only when there is a good cause shown. Furthermore, the bill establishes that the parental consent is not required for the adult adoptions. Adult adoptions happen for a myriad of reasons. In the case of my constituents, the adopting parent met the general parameters to adopt her son under the adoption laws for those under 18, including abandonment, abuse, and lack of financial support. However, given the adoptee's age, the process required a host of unnecessary steps for someone considered by law to be an adult. In the context of adoptions involving minors, showcase orders may be issued to notify the legal guardians, including known biological parents, when applicable, granting them the opportunity to object to the adoption. HB 243 eliminates the provisions requiring the issuance and service of a showcase order for adult adoption. The bill operates on the premise that adults, being capable decision makers, have the right to autonomy in managing their own circumstances. Instead of showcase orders, the bill will grant the court the authority to order investigations only when there is good cause shown before ruling on adoption petitions involving adult adoptees. This provides flexibility while ensuring essential information is gathered. The bill addresses various reasons, certainly for adult adoptions, including inheritance conditions and considerations, fostering relationships with adults, assessing crucial medical information, or facilitating reunification with birth families. By doing so, the bill aims to strengthen Maryland's family units while minimizing unnecessary barriers in the adult adoption process. I want to thank you for your time and your consideration, and hope that this is the final year that I have to present this bill for our families. Thank you so much.
Excellent. Thank you very much, Delegate. We have one question from Senator Sidnor.
Yes.
Thank you very much. Just by way to help me to visualize this, you were talking about show cause orders, but can you give me Can you give me a concrete example of?
Sure, absolutely. Let me give you the case of the constituent I talked of. Her now son was an immigrant, actually. His mother and stepfather came to this country, and upon coming to this country, ended up abandoning the young man. She wanted to not have the responsibility of managing her son, but wanted to maintain the relationship with her, I guess, husband, the child's non-father. So this gentleman, I think by maybe age 15, 16, was on his own for a while. The constituent ended up meeting this kid, helping him out a little bit, and finding out his issues. He had survived much on his own, but of course they developed a relationship, and she was really, made sure, he had his necessities, making sure he, can get the resources he needed, and then decided, they decided, this is this is my son. This is somebody I've been taking care of, that I care for. And going through the process, had to petition the one parent who was here, but the other parent who was in Africa, who could not be located, one. And two, I think was assumed that that parent potentially had died in the course of him being in America. And so this person at that time is of age, and so why am I petitioning, for instance, a woman a mother, right, who essentially put me out to be with someone who has cared for me and someone that I call mother. And in the case of my my other constituent here, actually from Delegate Grammer's district, she had an incredibly abusive mother. Her biological mother was incredibly abusive to the family, and has caused her a great deal of trauma throughout her life. And when her father married her stepmother, or now her mother, they had to petition the biological mother, and she had to petition the biological mother for adoption as it relates to her now mother wanting to adopt her as her daughter when she married her father. And so those are the scenarios that this bill is working to address. It does allow, and when the court does see there needs to be maybe some investigations that they can, but to kind of hold up that process to petition someone who has neglected you and abused you is a bit difficult and traumatic. I'm sorry.
So this the legislation is about creating a framework for having court orders to show good cause. Am I understanding that right?
I can't hear you. You sound
I
so
said
soft.
so. This particular bill is to help set up a framework so one can get these court orders for adult adoptions.
Court orders, or rather, again, removes the requirement for the adult to petition the.
So they don't have to go ask this abusive.
Exactly.
All right.
Exactly.
You.
I'm sorry.
All right, thank you very much, Senator Sinor. Further questions from the committee? Oh, Senator McKay. Sorry, I couldn't see your light there.
Thank you, Mr. Chair. So 2023 was put in, 2024 was put in. Other than just timing, is there anything?
No, I don't think there was a timing and issue. I think it just didn't make the list.
Just didn't make the list.
So it was on time.
All right, thanks for bringing a good
Yep.
bill.
Thank you. Also, just as a parenthetical, you're the crossfile for the bike bill, right?
I am.
Okay, so Senator Love's going to quarterback that on the floor, but we got you. All right. All right. So thank you very much, Delegate.
Thank you so much. I hope you really consider this. I
bill.
respectfully don't want to bring my traumatized constituents back to have to testify for this. So I appreciate your consideration.
Thank you very much, Delegate. I think we like the
Thank you,
bill,
Mr. Chair.
so thank you for bringing it
Thank you.
forward. All right, with that, that'll conclude the hearing for House Bill 243. We'll now move on to its Delegate Robertson and Crutchfield with House Bill 388. Welcome.
Yes, sir, and good afternoon, Chair Smith, Vice Chair Walshaker in his absence, and the Judicial Proceedings Committee. I'm Delegate Kent Roberson from District 25, and I'm here to speak and ask for your favorite report on HB 388, the Drunk and Drug Driving Points Assessment legislation that is before you. I will let you know just at the onset that this does not have a cross file, so definitely appreciate it. This is my second year bringing this to you, and I think it just got caught up just because there was no cross file, but it's a simple bill. In plain, it aims to correct an oversight in the Maryland Transportation Article, Section 21-902. In 2019, we decided that penalties for DWIs and DUIs should increase with fines, but it did not address the point system. And so this bill literally just puts in place what the points should be for those DUIs and DWIs. The MVA became aware that all the penalties have increased. The point system was not included in the legislation, and so they currently do not believe that they have the authority to assess points unless they have it written in statute, which is just really a technical change at the most. Therefore, I'm asking for a favorable report for HB 388 to assess DUI and DWI offenders with 12 points, which is the maximum number of points that can be assessed for anyone that is a repeat offender right now. And so I'll note that the Maryland State's Attorneys Association also has provided written testimony that goes into detail on their support of this, as well as having no opposition. Thank you, and I'm here for any questions if need be. Thank you.
Thank you, Mr. Mayor. How do you do, Delegate? Nice
All right,
to
how
see
you doing, Senator? Good to see you.
Is it your testimony that we intended to increase the penalties when we increase the fines? And did you do some research that shows that we meant to do it but didn't?
That's correct, because you'll see now on those, say, second and third, so this is applying to those that are after the third and fourth offense is how this applies. So right now, if you're at the second, you're already, especially a DWI, you already are automatically assessed 12 points. But it's not written in statute that for those repeat offenders after the third, fourth, and upward, that you are assessed any points right now.
So I'm just saying, when you looked at prior legislation, when we were increasing penalties, I wasn't here.
Oh, yes,
And
ma'am. Yes,
I
yeah.
wasn't here. I don't know if you were.
So I
but-
was not either, but
So
yes,
there
you're
we-
correct. That is
So then I
correct.
wanted to know if you could follow up and just give me some of that so that you could show me that in the prior bills where we did this, in our absences, that this was discussed and meant to happen, but in fact did not happen.
Yes, ma'am, I'll get you that, because that's actually why Delegate Crutchfield is a co-sponsor, because that was actually her legislation that put that in place. So I'll make sure you get that piece of legislation as well.
Thank you, Del.
Thank you.
I think that may have been my predecessor that put in the third or the second and subsequent DUI offenses, and then just it was an oversight that they didn't tack on additional points or any points. So you're just trying to cover this anomaly.
So
Correct.
was your bill, Mr. Chair? One of them was your bill?
I think it was then Senator, now Congressman Raskin that had this. If I'll look it up, but
Thank
I'm
you.
pretty sure.
Yeah, and I know on the House
Okay.
side, it was Delegate Crutchfield, so
Okay.
I think you might be right, Senator.
Maybe. I don't know, we'll check it out.
Very good.
Yes, sir, I'll find out it as well.
Yeah, but, all right, makes sense to me. Further questions from the committee? All right, Delegate, thank you very much.
Thank you, Senator.
All right.
Y'all have a great day.
Thanks, you too. All right, with that, yes. Okay, with that, that'll conclude the hearing for House Bill 388. We'll now go on to Delegate Morgan with House Bill 485.
Thank you, Mr. Chair. I am Doug B. Morgan, representing St. Mary's County. I would say in the future, these keys a little bit taller to help me out a little bit, but that's okay. I appreciate that. Mr. Chair Smith and Judicial Proceedings Committee, I'm here to represent House Bill 485. It's a delegation bill from St. Mary's County, which will better empower our sheriff and the courts to address programs which serve as alternatives to prison sentences for nonviolent offenders in the county. We have a day reporting program in St. Mary's County that was introduced 3 years ago. With federal grant funding, it has proven successful in enhancing an existing home detention program. The program gives offenders access to job training, mental health and substance abuse treatment, parenting, and anger management courses, among others. The legislation modifies language regarding the existing home detention program and inpatient treatment program to authorize the courts to order pre-participation pretrial. Say that again. This bill grants additional oversight and enforcement authority by mandating that participation in these programs require financial contribution from the individual, ensuring accountability. It improves and strengthens these existing and proven and successful programs, and enhances the ability of the courts to order rehabilitation rather than further punish those stuck in the cycles of poverty of addiction. I humbly request your request to favor report on House Bill 485, and this still pass over on our side unanimously.
Thank you very much, Delegate. Questions from the committee? All right, seeing none, thank you very much.
Thank you, appreciate it.
Excellent. All right, that'll end the hearing for House Bill 485. We'll now move on to Delegate Ebersol with House Bill 658. Welcome.
Thank you, Mr. Chair. Unlike my predecessor, I could probably use an apple box back here, but I'm fine. I can still see you, and that's good news. I'm Eric Ebersol. I'm testifying on behalf of House Bill 658. This is a bill that is motivated by the fact that a few years ago we separated JSEP, Juvenile Services Education Program, from the General School Board. They have their own board that, because of the unique challenges that they have. They are having a little difficulty populating the school board, so they've asked me to bring this bill to help them with a few things. One is that the superintendent of schools and the secretary of higher education don't have to serve on the board directly. They can have a designee instead. In addition to that, the terms are now going to be staggered, so we don't have to replace everyone at once. And the final part, I think probably the most important one, is if someone's appointed to the board because of an absence, they can then serve 2 full consecutive consecutive terms after that if they are appointed to do so. They also have a small provision about the number of meetings a year, reducing it from 1 every month to 10 a year. I think that was for some convenience. They can still have more if they want to. That's in essence the bill, and I recommend a favorable report.
Thank you. Senator Sidnor.
Thank you. Just one quick question. With the members that are currently on the board, if you're putting the alterations, how does that affect, or how, is there something already in place for rolling them off so that?
Yeah, there was, and I'm not positive. It's an excellent question. I believe that they have, based on the length of their current service, they were going to have those go off first when they staggered them.
Gotcha. Okay, thank you.
Further questions from the committee? All right, Delegate, thank you very much.
Thank you very much for having me.
Yeah. That'll conclude the hearing for House Bill 658. We'll now move on to Delegate Otto with House Bill 775.
Thank you, Mr. Chairman Smith and members of the committee. Good to see some of my friends from E&T that have moved across the road. But I have a bill here. I am Charles Otto, representing District 38A, Somerset, Worcester, and Wycomico counties. We happen to be the host, and I want to introduce this bill of HB 775. It's a notification. We happen to be the host of 3,000 folks that are incarcerated in Maryland in the Division of Corrections. And we have times that there are deaths in their, while they're being incarcerated. And this is a notification element that the local government and the state delegates and senators at the district will be notified of the cause of death and things. I get too much rumors and I see things in the newspapers, and I feel responsible for the facility and those that are there and incarcerated by the state of Maryland. And I want to have good information, not hearsay, and read it in the newspaper. So it's pretty simple. I don't think the Division of Corrections has weighed in as with any opposition, and I didn't specify in the bill how they can do it. An email is fine with me, just so that we have valuable and accurate information when it happens. So with that, I ask for your favorable report.
Senator James.
Thank you. Thank you for bringing this bill. I feel like, excuse me, my recollection is that Senator Benson may have brought a similar bill, and her concern is similar to yours, but in addition, she wanted the notice and I think a little more information provided to relatives and loved ones. Does your bill provide notice to relatives and loved ones? I'm sorry, I'm trying to read it.
Well, I would hope that that's the policy of the department now, but my interest is to be notified as an elected official that I'm inquired.
Right, yes, I see.
And I have constituents that work in the facility and things.
You just jogged my memory. I think during that hearing with Senator Benson, the Department of Corrections may have come up and said it is our policy to notify people. And I think the tension was that maybe that notice wasn't always timely, but or that there wasn't enough information given to the relatives about the nature of the person's demise and things like that. So I'm glad you're bringing this up.
I'm looking for simple, good information that I can make responsible responses to my constituents.
Yes, I agree. Yes, I agree, and I think it dovetails with.
And certainly it has HIPAA rules in it that I'm not interested in the whole history of things. But
right, but you're on the right track, sir, because if they die in our custody, you know, even with HIPAA, we have an obligation to let the public and public representatives know the nature of some of what happened.
And
Right,
I
thank-
just want to have good, accurate information, not
Exactly.
hearsay.
Oh, I know. Thank you, Mr.
Thank you.
Seeing no more questions, thank you very much. That ends the bill hearing for House Bill 775. I see Delegate Taylor. House Bill 814.
Thank you very much, Mr. Chair. Good afternoon. I am Delegate Kim Taylor, representing Prince George's County's District 23, and I'm here presenting House Bill 814 with regard to youth services bureaus. Youth services bureaus have a 50-year history in Maryland, and several years ago, most youth services bureaus, or YSBs, were defunded, and today more than half no longer exist. In my district, I'm fortunate to have a functioning youth services bureau at Bowie High School, where the YSB's programs include mentoring, mental health advocacy, dispute resolution, anger management, and most critically, life skills programs for chronically absent students at Bowie High School. Research in Maryland indicates that students who are habitually absent are significantly more likely to become involved in juvenile crime. YSB services are essential in preventing such outcomes, and data shows that YSB programs boast a 99% success rate in rehabilitating youth after being discharged from DJS. This remarkable success underscores the pivotal role these programs play in diverting juveniles from the criminal justice system and setting them on a path towards stability and productivity. In light of our recent discussions around our budget, I just want to add this piece that I did not say in the House hearing. According to the fiscal and policy note for this bill, YSBs are currently funded through discretionary grants from local management boards, or LMBs, which receive money from the Children's Cabinet Interagency Fund under the Governor's Office for Children. However, YSBs are not guaranteed any funding in law and must rely on local jurisdictions for additional support. Because of this structure, YSBs are highly vulnerable to budget cuts, especially during times of fiscal constraint. Here we are. Without statutory protection or a dedicated line item in the state budget, YSBs may not receive funding at all, as we have seen in recent years when several did not, and as we are forced to see today, facing today. So, however, to truly protect the fragility of YSB funding in the state budget, it must be addressed through statute. Establishing a legal requirement for funding would provide long-term stability and ensure that YSBs are not left vulnerable to shifting budget priorities. So, until we can convince our budget leaders to make a logical move back to the cost-effective YSB Bureau model, this bill, House Bill 814, requires the Department of Juvenile Services to report annually on its efforts to promote delinquency prevention programs, including evidence-based service providers like YSBs, which are widely regarded as the gold standard for community-based intervention and prevention efforts. For these reasons, I'm asking for a favorable report.
Thank you very much. Will we have a question? Yes.
Oh, hi. Hey, thank you for bringing this bill. I'm very interested. I happen to co-chair the Committee on Youth and Family and Children, and so we get annual reports from our LMBs.
Yes.
So I'm just going to ask you a few background questions to help me.
Sure.
Because I may bring this up with that group. Is the decision at the local level to fund or not fund an YSB made by the County Executive Council, or is it delegated to the LMBs?
It's delegated to the LMBs. And I want to call your
That's a
attention.
good, need to know that. Go ahead.
And in this cycle,
Right.
there's a little difference, right? So there are different criteria. So if you, maybe I can share this with the committee later,
Yes,
or
we'd
you
love to.
directly.
Yes, definitely.
On March 14th, there was a notice of funding availability through the Children's Cabinet Interagency Fund. And this was the only eligible recipients are the LMBs. And there's specific criteria in here that their providers, so to speak,
Yes.
would qualify. And we're concerned now that the YSBs might not qualify under the new criteria.
Who established that criteria? Was that the governor's
This is the governor.
office of something and something?
Yes, for children, the Office of Children.
Okay.
Yes.
Yes, would you please, yeah, very much like to have
And
that
I mean, I'm
shared.
concerned also because one of the criteria is the 30% poverty level, and I represent District 23, and even though our Bowie YSB helps, hundreds of children a year.
Right.
And 10,000 across the country, across the state, by the way.
Right.
10 or 15,000 kids, we're in jeopardy of losing ours.
Poverty is poverty, so I don't know
Yeah.
if the percentage is very much
And,
telling.
delinquent children aren't necessarily impoverished all the time.
Well, that's,
So,
yes, that's true, too.
and
And then can I just clarify one other thing? So what's amazing about this, it's sort of like what we do in Medicaid, at least when they start out, they're very generous. So the state has, if you qualify, and if an LMB will fund you,
Yeah.
the state's going to pick up, am I right, 75% of this anyway, and you'll be, and the locals would have a 25% obligation, is that the law?
I'm not sure if that same percentage flows through the LMBs, but if it does, we can find out.
I just
Maybe it's
read
part
this
of
and
this
said the
report.
state and local must jointly fund, the state must provide 75% of the funding, which really is so.
For the LMBs?
Well, for the YSBs.
Okay, through the LMBs.
Right.
Okay.
Right. Look at us, we sound like we're talking about alphabet, we have a new language of alphabet.
Yeah.
But my point to you, Delegate, is you
Sure.
make a good case because not only is this important, but it's not as if it's a 90-10 match where the counties have to come up with 90 and the government's only giving you 10. They are showing, the state is showing their commitment with this 75%, being very generous.
Yeah.
So we would want to encourage, perhaps mandate, but certainly get these YSBs funded at the local level, which is the mechanism we currently have.
Especially for their per pupil ratio, they're the most cost-effective statistically than the other diversionary programs that
But
we.
then I'm going to play devil's advocate just a little bit.
Sure.
Is your bill in a way a mandate to the local governments to fund something? I mean, let's.
Not for the locals, no, not at
Okay,
all. In
all right.
fact, I had a bill last year, coincidentally, it was the same number, where I was asking that the state put a line item in the budget at $4.8 million to continue the funding for YSBs. That didn't happen. So now I'm here just asking for a report.
Which is, right, incremental steps, maybe.
Sure.
And once you have data, it may, be even more persuasive as to what you go for.
Absolutely.
All right, thank you, Delegate.
Absolutely.
Thank you.
Thank you for your questions.
All right, seeing no more questions, thank you very much. That ends the hearing on House Bill 814.
Thank you.
Are you here for Delegate Edelson? All right, House Bill 1442.
Good afternoon, distinguished committee members. For the record, my name is Marley Mielich. I'm not Delegate Edelson. I'm here presenting HB 1442 on his behalf. He's very sorry he couldn't be here, but they're voting out the budget, and he just cannot be present right now. All jurisdictions have chronic absenteeism and truancy issues. Most jurisdictions reported an increase last year in their truancy rates. BCPSS, which is Baltimore City Public School System, reported a marked decrease, but still sits at around 38%. It's clear to Delegate Edelson that significant work has been done to address the issue. However, additional resources are very likely needed to continue to improve. Other jurisdictions on the Eastern Shore and in Prince George's County have introduced truancy reduction pilot programs. A Department of Legislative Services report was released in 2008 that investigated the impact of those programs. The program involves an assessment of the students' absences and what is stopping them from attending school, an introduction to services, and a requirement to attend school for a 90-day period without any unexcused absences. The report showed that approximately 43% of participants were successful in completing it and attending school regularly for the following 90 days. What the report, however, was unable to uncover because of a lack of data was what happens on day 91, right? Kids are really smart. If you tell them that they have to do something for exactly 90 days and then the adults in their life will get off their back, there's going to be plenty of kids who do it right up until they don't have to anymore. 90 days is a long time, and I certainly don't have to tell anyone in this room that 90 days is a long time. But the question is it long enough to build good habits? Is it going to help us increase GPAs? Does it improve graduation rates? Are there other marked improvements on student performance that can be achieved within 90 days? The 2008 report was unable to provide longitudinal data. Also, it was published over 15 years ago and before COVID. This bill would commission a report that would investigate those questions and see if such a program would be successful in Maryland's 8th Circuit, which is Baltimore City. Given the challenges you all face in all of your jurisdictions and the incredible investment that's being made in the blueprint, Delegate Edelson believes you all must do everything you can to keep your students in the classroom. After discussing the bill with the judiciary, they offered an amendment to strengthen the information included in the final report by adding some additional metrics. Delegate Edelson fully supports the amendment and has submitted it. You should have it in your materials for today. Delegate Edelson urges the committee for a favorable report on HB 1442, and I'm happy to take questions on his behalf with the caveat that if I don't know the answer, I will ask him the question and we will get you the answer.
Thank you very much, Senator James.
Hi.
I want you to convey that to your delegate that you did an excellent job, and because I don't know who Delegate Edelson is, I thought you were Delegate Edelson, so that's a compliment to you. Very, very good, very good. I'm so glad you brought this bill, our delegate did, and I am very surprised. You can tell him that when we do these kind of pilot programs, we don't automatically ask and get reporting, and I think one thing the state needs to do across the board with existing programs and then future programs is to get some reporting and feedback on everything we're doing to see if it makes sense. But I think what you said, so I can understand, there was at least one report, but that was 15 years ago.
In 2008, yep.
So if you don't know, then just get back to us. I'm wondering what prompted that report and then why we didn't get additional reports. If you know now, could you share it? If not, could you get back to us?
No, I don't know, and that report was generally on truism or truancy in the state.
Sorry, say it again.
That report was generally on truancy in the state and
Okay.
discussed a number of different programs that different jurisdictions were trying. I'm really happy to forward it to your office or to the committee. And then truancy reduction pilot programs were included as like a subsection of that report.
Yes, I would very much like the report. I imagine the committee would too. So thank you very much.
Yeah, of course.
If I might ask, do you know if the delegate knows that there's already an annual report that does some of this?
I know that there's other reporting and I'm sure the delegate also knows that there's other reporting around truancy and absenteeism rates. I haven't reviewed it, at length, so I certainly couldn't say if it meets the intent of Delegate Edelson introducing this bill.
All right, that's what I was curious if there was something different that he was looking for that's not already included. Mm-hmm. All right, thank you. All right, seeing there are no more questions, that ends the bill hearing for House Bill 1442 and ends the hearings for today. Thank you very much.